What provision in Washington law says that in order to have an asset protection supplemental needs trust for your spouse, it must be created through a will? What I'm talking about is the rule in Washington that says if you want your spouse to be able to have assets after you've died, you can only do that through a will with an asset protection supplemental needs trust. And if you have the right kind of estate plan, then Medicaid won't count the assets that are in the trust. So we often get the question, well, where is that rule? So let me tell you where that rule is. It is under the Washington Administrative Code, section 182-516-0140. And I'll be really specific about it for those of you that want to check it out. But again, it's 182-516-0140. What it says is that a testamentary trust is a third-party trust created by a will where the trust is in the will and the estate is the grantor. It goes on to say that there's no requirement that the state be named as a remainder beneficiary of such a trust. There is no requirement, if the beneficiary has the power to acquire the assets from this third-party trust, then the trust is an available resource. And so what that means is that the beneficiary cannot be granted what we call standards. This trust has to be a discretionary trust. The trustee can only give distributions when in the trustee's discretion they are appropriate. The beneficiary, who will be the spouse, the surviving spouse, can't demand, I need this money for my health, education, maintenance, support, anything along those lines, because that's called a standards trust. And if this trust is set up as a standards trust, it fails. It doesn't work. The WAC, Washington Administrative Code, we call it WAC, goes on to say, if the beneficiary has no power to access or control trust assets or distributions as described up above, then the trust is not an available resource. So when it comes to regulations and statutes, it's not necessarily easy reading. So if you want to take a look at the provision, please feel free to do so. But in summary, what all of this means is that if there's a couple and they want to make sure that when they have passed away, that their spouse will never become impoverished from long-term care costs, the type of estate plan in Washington state that they need is one that has a will that includes a testamentary meaning it refers to the will, supplemental needs trust for the benefit of their spouse. How that is set up is on the death of the first spouse, through the probate process, the will is probated, this new trust is created, this new trust meets these standards of this particular provision of the Washington Administrative Code, 182-516-0140, and this trust will not have the surviving spouse as a trustee. The surviving spouse will be a beneficiary. They may not demand distribution of any assets from the trust or say that they're in control of the trust, because they're not. They're only a beneficiary. And if you meet all of that criteria and the trustee has discretion, then the state need not be named as a remainder beneficiary. All of those assets in that trust are non-countable for government benefits purposes, for Medicaid purposes. Why that's so important is that this nest egg, this protected money in the trust, will never count against your spouse when your spouse applies for Medicaid long-term care benefits. It is a very important planning tool that we have in Washington State. It is a tool that if you have any concern about long-term care costs for yourself or your spouse, talk to your estate planning and elder law attorney. And please keep in mind that this kind of a trust can only be created by a will. If your plan is based on a revocable living trust, then that is the wrong kind of plan to protect assets for your spouse.